Good morning. I'm Tom Kimball, Traffic Safety Resource Prosecutor with the Tennessee District Attorney General's Conference. I'm here to talk to you this morning about the new search warrant law, which was passed by the General Assembly in 2014. Beginning July 1, 2014, we have a new law in Tennessee that will permit the use of electronic search warrants. This new law, Public Chapter 769, amends Section 40-6-109, TCA 40-6-109, and it allows us to get into the 21st century. Previously, the method that we have used to get search warrants has been the same for over 100 years. It's the same as in horse and buggy days. An officer would have to get to the judge or magistrate, sit in front of the judge or magistrate, and swear to the facts in the affidavit in order to get a search warrant issued. In Missouri v. McNeely, the Supreme Court practically mocked such procedures. They did so by showing the numerous states that had adopted laws, and the federal government, concerning the use of electronic search warrants so that a search warrant could be turned over in about 5 to 10 minutes, as opposed to the numerous hours it takes here in Tennessee currently. So the General Assembly, in response to Missouri v. McNeely and our request, passed a new law that allows the use of electronic search warrants. I want to explain it to you a little bit now. The entire law is 2 paragraphs. Public Chapter 769. Representatives Lamberth, Carter, Shipley, Hardaway, and Sexton worked for this in the General Assembly in the House of Representatives, and our sponsors in the Senate were Senator Green and Senator Burks. They worked hard to explain this to make sure that all the legislators knew that these aren't really radical changes. It's simply a change of method as opposed to a change in the warrant itself. So first and foremost, an officer who develops probable cause that he needs the evidence involved in the case, and this might be a blood test in a DUI case, it might be a search of a house, it might be the search of a car, but he develops the evidence for probable cause and makes a determination of whether or not there is probable cause to seek a search warrant. The officer then writes it. He can write it on his computer, he can write it on a form, he can write it on a pad. However he writes it, whatever is written, it's going to be judged in the 4 corners of that document. At that point in time, the officer can now submit that written request or affidavit by fax or by email to the magistrate or judge. Once a magistrate or judge has it, he reads it, decides whether or not he's going to issue it. The officer then has to communicate with the magistrate or judge by electronic means that is audio and visual. That can be by the use of Skype, FaceTime, the video on GoToMeeting, any number of audio-visual types of sources, as long as the magistrate can see the officer and verify that the officer is who he says he is, and watches as the officer is sworn, then we're good to go. At that point in time, the magistrate electronically signs the affidavit and sends it back to the officer, who can then execute it. Now, he uses an electronic signature, then sends the information back to the officer. Officer executes a search warrant, leaves a copy with the suspect, as he does currently. The magistrate isn't done at this point in time. The law requires him to deliver a copy of the search warrant then to the clerk and to keep a copy himself so that later we can prove authenticity if that's challenged. Nothing else in the search warrant law has changed. Simply a means of a quicker delivery, a quicker process to permit a search warrant to happen. In Missouri v. McNeely, the court requires search warrants in all cases unless there are exigent circumstances that make that impossible. Now, with the new search warrant law, it's going to be much more feasible to get a search warrant than it was in the past. In the past, if you were in a small rural community in one of these districts that runs all the way from Kentucky to Mississippi, it might be very, very difficult to find a judge or a magistrate at 2 o'clock in the morning who can sign a search warrant. By being able to do this electronically, rather than having to drive for 2 hours to get a search warrant signed, it can be done in a much quicker period of time. Now, under Missouri versus McNeely, we could still get search warrants based on exigent circumstances, but we would never really know if the exigent circumstances were good enough until the court ruled on whether or not the evidence was going to be admissible due to the exigency. This is going to alleviate that and hopefully make the process cleaner and work better. Now, this law is in effect from July 1, 2014 to July 1 of 2015. The legislature anticipates changing it next year so that the legislature can conform to the new rule that comes from the Supreme Court Rules Committee. The Supreme Court Rules Committee has tentatively blessed a new rule that this law is based on. However, it takes a long time to get a new rule, as they have to have the comment period and look at all the comments that are received concerning the rule and see if they're going to change anything in it or not. So the legislature anticipates receiving a new rule from the Supreme Court at the beginning of the 2015 legislative session, and then they will make sure that this law conforms so that the law and the rule are consistent. We don't end up with a conflict of laws. So I hope this is useful to everyone. I hope this will be used and embraced, and I hope that we will have less situations where we discover that a blood test is not going to come in a DUI case because the court decided there were not sufficient exigent circumstances to excuse a search warrant. Now we hope that the most common means for getting that blood test will be through the use of this search warrant, which can now be obtained in a much more expedient manner.